memorial, the draft memorial. You go through the grammar, spelling, so on. And again, if you notice any weird sentences, if you notice any oddities, this is where you, through your proofreading, you identify it, you mark it down, you amend, delete, so on. Continue to refine your work. As mentioned before, you either add more sources or you add more layers. By layers, I mean you elaborate further. If there are 4 elements and you realize only 2 elements have been mentioned in the draft, that's where you add the remaining 2 elements with their substance, sources, and so on. And then stage 4, this is what some seniors from Law they call the nitty-gritty part of the uh, post-drafting stage, is you check the competition rules. You check what are the sections required. This one is basically a throwback to what we mentioned in part 1, preliminaries. What are the mandatory sections in your memorial? Cover page, table of content, list of abbreviations, index of authorities, statements of facts, so on and so forth. If your rules, for example, say index of authorities, you use index of authorities. Do not call it list of authorities, table of authorities. You copy what is exactly required and named in the rules, because you never know if your deviation would result in a penalty, and you don't want to be penalized before your content is reviewed. Penalties usually look at the non-substance of your memorial, the formatting, the structure, whether or not it complied with the rules. So if you're going to be deducted points, make it and limit it to just your content. Don't suffer penalties in areas that you can control in its entirety, because you can control whether or not you have a cover page, table of content, statement of facts. You can control your formatting. You can control your mandatory structure, outline the rules. But your content is something you cannot control. Eventually, that's up to the individual markers. But where it is within your area of control, monopolize it, maximize it, reduce chances for penalties. Also, in some competitions, they ask or they require that you have a table of abbreviations. But in the ILSA UniSZA competition rules that I'm using for today, they do not have that requirement. So do not add a table of abbreviations for your memorial for the ILSA UniSZA competition. That's not required. Okay, next page. Okay, post-drafting. Again, read all the competition rules. This is in stage 5, your final check. Read all the competition rules. Have a checklist of what are the requirements you need to comply with. Check every aspect of your memorial, the margins, the size of the document, the type of font you're using, the size of your font, the line spacing, how you number your pages is important, whether or not you're in the word limit or above the word limit. Again, refer back to part 1 preliminaries, and keep in mind your approaching deadline. If you have 1 day before your deadline and you're not at stage 5, that's a sign that you need to speed up. You need to move forward. You need to be more aggressive in your review. But doesn't mean you skimp, you mess up the quality. No, you still have good quality. It's just that you need to be faster. Now, stage 6, submission. Before you submit your memorial, you will have a finalized copy, a finalized draft. This is where theoretically everything is perfect. Theoretically, everything is according to the rules. Theoretically, everything is complete. So gather your teammates, have a meeting, physical or online, and go through the entire finalized memorial with your teammates. This depends on how you define checking through. But for my personal experience, we would go through the memorial page by page, and if possible, where we have time, line by line. Because sometimes errors or issues, you don't see it at face glance. If you go through the line by line, then you start realizing like, wait, this is spelled wrongly. Wait, there's a wrong sentence structure here. Wait, something's missing a footnote. Or wait, this should be footnoted here and there, and so on. So again, page by page, line by line, that's your choice. But if you have time and you have a lot of spare time, use it. Take advantage of it to try your best to limit issues with your memorial. And submit early. Generally, competition rules will say that if you submit early, for example, you submit 2 days before the deadline, but then before the deadline ends, after you've made your first submission, you realize you named the parties wrongly. Like for example, United States of America, you forgot America. You just put United States in your memorial and you want to correct it. You can. You can just resubmit your memorial, the corrected version, within that timeline before the deadline ends. It's totally fine in most competition rules. They will not prejudice you. They will not penalize you because you are still within your deadline. That is why it's very important to submit early. Because when you submit early and you have time, and then you check again and you see errors, you can identify, correct, and submit without penalty. For me, it has happened before. We were a few hours before the deadline. We submitted it at 1 a.m. And then we realized, like, wait a minute, something's wrong. Why is the name of the parties not matching up with the mood problem and the mood facts? Then we cross back to what we submitted and we're like, oh my God, guys, we wrongly named the parties. But we quickly amended the document and resubmitted it, and we got the confirmation of submission, and all was good. We did not get any penalties from it. So yeah, submit early is very important. So after you submitted early, all is well. This is where you celebrate. This is where, if you've been missing out sleep, if you're not if you're not eaten yet, if you've not drank anything the past few hours, do it and then you sleep and rest. Whatever happens afterwards, you leave it up to the markers. You've done your best to make sure you've complied with the regulations. You've done your best in the drafting of your content. Whatever happens afterwards, that is for the markers to decide. For now, you celebrate, sleep, and prepare for your oral submissions and trainings. Yeah. Next. Okay. So this is where we talk about concise arguments. This is an example of memorial before drafting, sorry, memorial before editing and review, and memorial after review and editing. So on the left is the one where it was not edited. It was just a complete draft. And on the right is the one after you've done your editing and review. So again, you can see that there's a lot of change. There's a lot of differences. The one on the left is very clumped up, big paragraphs, no flagging, no identifying markers. Some sentences are not even properly substantiated with footnotes, compared to the one on the right that is flagging. It's clear. There's the paragraphs are not huge, and there's substantiation for each sentence where possible. Yeah. Next. Okay. Use active sentences and always flag if you have to make several points under one main point. So active sentences is, for example, you want to say respondent breached something. So don't say that international law was breached by the respondent. No, just say respondent breached international law. If you want to say hypersonic nuclear missiles are not good under international law, just be direct for it. Active sentences basically means be direct, no need to uh, beat around the bush, be straightforward. That's how I would interpret active sentences. Flagging, again, very important, as we can see in the circled red areas. First, second, all of these are very crucial to give out a very clear argument. And this is what you should achieve after you've edited and reviewed your draft. Next page. Fine-tuning. So again, this is very repetitive, but it's very important. All these things we should mention in part 1 and also in the few stages of a post-draft. Check again and again. Every tiny detail counts, because from what I remember, when they check your memorial, it depends on the level of competition and how many markers they have to judge your memorial. Sometimes they just randomly check a page on your memorial and see whether or not the formatting is in line with the rules and regulations. So if you have 300 footnotes or 200 footnotes, make sure each and every one of them are in compliance with the rules and regulations. If you have 50 paragraphs, 80 paragraphs, again, each and every one of them should be in compliance with the rules and regulations. And if you have deviated slightly from a certain format of citation, make sure that deviation is allowed and also consistent with the other deviations you might done. So if you don't put a comma in one citation of a footnote for a book, for example, oh my God, I forgot. Brownlee's Principles of International Law. You don't put a comma in one of the citations of it, the original citation. Then make sure every other book citation for other books follow that standard. It's consistent, it's standardized. Next page. Oh, sorry, next page. Okay, thank you. Again, this goes back to the preliminaries. Based on your ILSA, the ILSA UniSZA Moot rules, these are the requirements of the memorial based on Rule 7.1. So these are the 8 parts of the memorial that are mandatory. You can skip out, and you should not add anything to this structure. They should not, if they don't ask for a table of abbreviations, do not add table of abbreviations because that could be a penalty point. Next page. Okay, these are samples of cover pages from memorials. The one on the far left is from Monroe E. Price Media. The one in the center is Philip C. Jessup, 2022. And the one on the right is from the Tunzaki competition of 2022. So these are the cover pages. For moots before the International Court of Justice, I would recommend to follow the cover page style in the center and far right. Because from my understanding in UM, we essentially replicate the style employed in other universities as well. Yeah, the sample memorials of Jessup have this style, the ICJ logo, so and the name of the ICJ, the location of it, so on and so forth. Next page. So these are table of contents. It's very small. I apologize. There are limits to what I can put in screenshot. But yeah, these are the table of contents from Jessup, the Jessup Memorial. So again, this is what we mean when you want clear structure and flow. So essentially when they look at, for example, point 2, the one in the center, they immediately know what your stance is, what your main arguments are, capitals A, B, and C, and then your sub-arguments in the uh, following subheadings and so on and so forth. Next page. These are index of authorities. Index of authorities, I do not recommend for you to do it manually because sometimes a case or treaty or source is going to be used in, for example, 10 pages, and it's very difficult to keep track. So what I would recommend is for you to do trial and error, not on your actual draft, but on a separate trial and error document on how the Microsoft Word system software, I forgot what it's called, but essentially it's called marking. Yeah, the marking system. So try to learn it and how to use it because it looks nice. If you can do it well and you can invest time and you have a lot of time and you do it slowly, footnote by footnote, this is the final product. And you won't have to manually go through each and every page. But yeah, it's a nice way of doing things. So yeah, trial and error. Marking is taxing. So make sure it's not just one person handling marking. If possible, one person handles the applicant side, one person handles the respondent side. And when they mark authorities, do not ever do it on your online document. Have a local file in your laptop because one of my seniors, they tried to do marking on a shared online document. So you have like, imagine one person trying to mark all of this and there's 4 other people online on the document, probably typing. Apparently, according to her, the document crashed and whatever she marked was gone. it did not record. So imagine if you mark up to your 200 footnote or your like 50th footnote and everything is gone. So don't do that. Where possible, be safe. Yeah, next page. Okay, these are samples of statement of jurisdiction on the left and a sample of questions presented on the right. So statement of jurisdiction is generally, you do not need to research. You can just take from samples online as well. Just need to switch out the names of the parties. And if there's any particular dates, add in the more accurate dates. Questions presented, they are basically the legal issues. So you just need to copy paste, not say copy paste, but just take the legal issues from your moot problem and switch it around. For example, the whether um, Azura's military attacks violated international law, so on and so forth. So in your case, you only have two legal issues. So your questions presented only have to be two. But in JASEP, the reason why there's four here is because we had four legal issues. Next page. These are statement of facts. Again, I'm so sorry, it's very small, but statement of facts is essentially a brief retelling of the facts to your moot problem. You don't have to spend too much on it. You can actually do it near the end of your drafting phase, near the end of your editing phase. You just need to go through your moot problem and make a clear, concise, straightforward story of what happened and why you are now before the International Court of Justice. So statement of facts, you can be creative. You can do what we did here. We did bullet points, brief paragraphs, we did mini headings. These headings are not linked to the table of contents, so you can go creative on how to frame the storyline to favor your case. And if you go through moots in, for example, Law Asia, foreign direct investment moots, which involves commercial transactions and business deals, and for example, companies and how they relate to subsidiaries, you can use what's the word for it? Graphs. You can use tables to further and better illustrate what's happening in the current case. So yeah, statement of facts, you can be creative. Also take note, some competitions, they outline word limit for a statement of facts. So, but if there's no word limit, doesn't mean you can make a 3,000 word statement of fact. Just make it very brief, if possible, below the 1,000 limit word mark, word limit. Next page. These are summary of pleadings. So summary of pleadings is a summary of your arguments for each legal issue. So if you have two legal issues, a summary, you just need to summarize what are your arguments for those two legal issues. Here, we had a word limit for JASEP, if I recall, but if you don't have a word limit, again, don't go overboard, limit yourself to below 1,000 words. So yeah, it's you don't have, yeah, it's just one paragraph. That's why it's a bit disjointed, but yeah, just one paragraph to summarize your points. Next page. Okay, these are a sample of pleadings. This is from the Tunzaki Moot, ground 4, regarding torture and slavery. So again, you see on the first page far left, again, I apologize for the small size. On the far left, you have the main ground, which is ground 4. And in the center page, you'll see main argument A. Main argument A will have 3 supporting points. Points 1, point 2, point 3. And then on the page far right, you'll see main argument B. Main argument B will have 1 supporting argument. And then up below that, you have main argument C, which has so far on the page 1 supporting argument. So this is how you structured it. Yeah. Next page. These are prayers of relief. Okay, this one I apologize. I should have made it bigger. But okay. In every mood, same goes with how you submit in real life. You will want to conclude your case with what you want from the court. For example, do you want compensation? Or do you want a declaratory remedy? Do you want an apology? Essentially, this is what you want, prayers for relief. But generally, it's just your legal issues, but you change the wording to favor you. So for Azura's prayers of relief would be a declaration from the court that its military attacks did not violate international law, and that Azura does not have to provide reparations to Roxana. Yeah, these are samples for prayers of relief, and they are part of pleadings. So the word count in your prayers for relief, are part of your word counts with your main content. But again, this may differ based on your competition rules, so always check your competition rules. But if there's any ambiguity or confusion, you can always email the committee in charge and ask for clarification. Next page. Yeah, that's all. Thank you so much. That's all. If you have any questions, please feel free to ask.
Thank you so much, Mr. Akmal, for such a comprehensive talk in regards to the memorial submission. After this, I believe that all participants will have a general idea on how to draft their memorial submission accordingly and which mistakes to avoid while drafting the memorial. So let us move on to the Q&A session. Um, if anyone have any question right now, they want to, you can turn on the mic. If there is no question, I have one question which comes from the registration form. Okay, for the first question is, um, should we follow the FILAC method when drafting the memorials? FILAC method.
Sorry, what method?
The FILAC method, FILAC.
Is it the same as ILAC?
I'm not sure, it's FILAC.
FILC.
It's almost the same, but the facts are in the first, so facts, issue, and law, and the rest. So I
Oh,
think
okay.
it's feel like it.
Okay, makes sense. Okay. So sorry because I remember ILAC, but I did not know there was a variation of the facts in front. Um, you can use the method of how you draft answers in exams and tutorials to draft your memorial, but I would recommend that do not always stick for it because sometimes the law that how to say the law, the facts, and application, they are not always LAC. Sometimes it can be application, law, and conclusion, or it can be different, or it says conclusion first, followed by law and application. It really depends. Facts wise, from my experience based on memorial drafting, the facts will usually be stuck together in the application. So, like for example, your heading is the respondent state uh, the respondent state violated the freedom of expression. So your law would be the freedom of expression is provided under Article 19 of the ICCPR. And there are three requirements for a valid restriction. And then your first subpoint is the respondent state violated the test of legality. So your application would immediately just include the law and the facts. For example, the Human Rights Committee sorry, the European Court of Human Rights in Delphi v. Estonia opined that any oh sorry in Delphi v. Estonia, the European Court of Human Rights opined that any valid restriction to the freedom of expression must be founded in clear law. That's your law. Presently, in our case today, the respondent state the respondent states legislation restricting the freedom of expression does not comply this requirement. That's you that is then followed by elaboration with reference to the facts. For example, the law uses vague words. It does not, these words are not defined internationally or domestically in any other jurisdiction. 1 point. And then you refer to the statute in the moot problem. And then secondly, what's the word for it? The respondent respondent's legislation does not have a requirement of mens rea. And then you make reference again to the facts of the problem to substantiate it. And then you conclude it with a legal authority. Thus, accordingly, the legislation is vague, overbroad, and excessive, therefore invalid. Or you footnote it with legal authority. So here you can see that the law, the application, and the facts, they are intermingled, they are interwoven to each other. So there is no clear LEC or ILEC or FILEC. It's all mixed up to a certain extent. Yeah, that's why if we go back to the sample pleadings, there's this 1 point regarding attribution, whether or not the conduct of the military is attributable to a particular state. So you can have your starting point be a decision of the ICJ or decision of any court. For example, in DRC v Uganda, the ICJ concluded that the conduct of the Ugandan military was attributable to the Ugandan state. Footnote. Presently, in our case today, the conduct of the applicant's military forces are attributable to that of the applicant. For example, the email spam, the harassment, so on and so forth. And then you footnote it to each paragraph of the moot problem that says that particular fact. So yeah, you can to summarize, you can stick to FILAC, ILAC, or IRAC, for example, but they are not fixed rules for memorial drafting. Yeah, they can be the basis, but they are not always correct in some extent. I hope that answers the question. So sorry if it's a bit confusing.
And then the next question is from the chat box. What are the key elements that make a strong legal argument in a moot court competition? And how can one ensure that their written submission meets these criteria?
So generally speaking, because you're arguing in a court, I mean, even if you make an argument outside of court, you should always have a clear structure, important. Secondly, you have to have authorities. If you say that Azura's claims against Roxana are not admissible before the International Court of Justice, that is your claim. So that claim must be supported by a main point. What is your main point? Azura came to this court with unclean hands. Why do you say that? That is where you bring your authorities. The doctrine of clean hands, the cases of your authority could be the dissenting judgment of Judge Schwebel in Nicaragua, where his excellency opined that since Nicaragua came to court with unclean hands regarding their conduct inside Nicaragua, their claims against the United States premised on that unclean hands is inadmissible and should not be entertained by the court. So yeah, you have to have authorities. And on this point of authorities, just to slightly deviate, you can use dissenting judgments or separate opinions. It's completely fine because the definition of judicial decisions in Article 38, 1D, which is the source of the ICJ, the International Law Commission has interpreted it to also include not just majority judgments or main judgments. So dissenting judgments are also a good place to build up your authorities. It's completely fine. And okay, other than structure authorities, I think the clearest way is honestly good drafting. You can have your claims, you can have good structure, you can have good authorities, but it's important that you convey it well. So again, be straightforward, use active sentences, use flagging, and ultimately research. Research and research more. There's nothing wrong with having an abundance of information. There is everything wrong if you do not have enough information. So yeah, that is what I think would make a strong case in court, both orally and also in your written submissions.
And there's also another question. Uh, what are some best practices for organizing and structuring a written submission? And how can one ensure that their arguments flow logically and coherently?
You can have like, for me, sometimes I have either a Word document that I just use for the site to take notes or a Google Doc for online meetings. Oops, sorry. And then you just lay out your main point. For example, uh, Azura has violated international law by launching military attacks on Roxana. Then your next stage is why. So it's what, why, how. And you just replicate this formula again and again. I think that is the best way to structure your argument in a logical way. But at the same time, an alternative route is you should read your own argument and see whether or not a third person who reads your argument can see the flow, can understand the flow. So it's important that when you draft your points, if you're a bit uncertain if it's good or bad, get the opinion of your teammates or get the opinion of a senior or a friend, just that without them knowing the mood problem, but just them looking at your points, whether or not they can just grasp it like that within a few seconds. So yeah, what, why, how, and also independent review, either from your teammates or non-teammates which are not in the competition, is totally fine. That's a good way of identifying whether your argument is logical or not logical.
Okay. Any more question? One last question.
I have one question. It's regarding the word count. I find that it's very difficult. If you exceed the word count, I find it very difficult to cut down the arguments, especially choosing which arguments are more important than the others. And also, could I ask if paraphrasing is okay, especially when it comes to citing cases in your memorial?
Okay, we'll take that level by level. So word count, yeah, I understand. It can be very difficult, especially when you've done a lot of research and your argument appears very substantiated. But again, you have no choice. You really have to choose which one you think is the least controversial argument that has been tested and accepted in a court of law, be it ICJ or not ICJ, and then determine whether or not it's stronger than the other arguments. If your argument is completely, for example, novel, and the authorities for it are separate opinions, dissenting opinions, and you have this hunch that this argument is probably not a good argument and would be rejected if it was presented before a full bench, then you should not go with it. Because generally speaking, novel arguments are a bit hard to substantiate. But again, it's a gamble. You never really know whether or not a particular argument is the best or the worst argument. But just look at the ones that make logical sense. If, for example, you raise an argument of jurisdiction, but the thing is, in your moot problem, both parties have no issue of jurisdiction, then you should clearly delete that argument because it's going to take up word count. Yeah. But for example, if you have an issue of admissibility, it's not indicated in the moot problem if Roxana opposes the claims raised by Azura. So you could run an argument, like a preface that, wait, before we go into the merits, let us discuss whether or not the claims can even be brought before this court in the first place. Yes, that's fine. But again, if you think it's a non-issue, and if you think that you're just going to waste time and it's taking away from important substance, you can delete that admissibility argument and just stick to your merits, the core substance, the legal issues. Yeah, I think it should be fine, the 5,000 word limit, because you only have two legal issues, and yeah, it's only two legal issues. It should be fine. If it was a 4,000, if it was a four legal issue moot problem with 5,000 words, then I would then you have to be very cautious, even from when you're drafting in the first place. Okay, paraphrasing. Um, it's actually okay. If you want to save up word count, if the word count includes your footnotes, and you really have no choice, it's completely fine. For example, Nicaragua v. United States of America. You can abbreviate United States as just USA because it's a common abbreviation. Yeah. Another example would be DRC v. Uganda. In your memorial text, like your main content, if you say DRC v. Uganda with the spacings, it's 3 words. But if you put DRC / Uganda, no spacing, it's just 1 word. It's fine as well. Yeah. So as long as it doesn't make the case name vague and it is not completely radical, it should be fine. Yeah. Sorry, and also the same thing goes for treaties, because treaties have long names, and then they even have longer those details like UNTS or whatever citation they put in the back. You can delete that and you can just put, for example, International Covenant on Civil and Political Rights, bracket, adopted the date, and came into force that date. Entered into force that date. And even the dating, you don't have to exactly use, for example, 1 space January space 1966. You could just put 01.01.1966, no space. It'll just be 1 word. It's a very very stingy way of saving word count, but it helps a lot, especially when you have a lot of footnotes as you progress onwards. I hope this helps.
Okay, so I'm afraid we have to end this Q&A session now because we are running out of time. So thank you so much, Mr. Akmal, for taking your time to answer the questions given. Okay, nonetheless, before we end this segment, let us take photos as well. Okay, technical team.
Oh, just a moment. I just realized my background is not the one you sent me. Just a moment. So sorry.
Can you change? Oh, it's
Yeah.
okay, it's okay. All participants can open their camera if there are no technical issue.
So I'm going to start with the formal one first. Is everyone ready?
Right, is everyone ready?
All good.
Okay.
Okay.
3, 2, 1. Okay. Okay, now we are going to take the informal one. So let's do some pose. 3, 2, 1. Okay, done. Thank you, guys.
Okay, thank you so much, Chase. Okay, once again, we are so grateful to have Mr. Akmal thank you so much for your time and effort in joining us today. Your support means the world to us. Have a great day ahead. Okay. So now we have come to the end of our workshop for today. A huge thank you to all the participants for your support. Give a round of applause to yourself for completing today's workshop. Okay. As a representative from the committee members, we hope that you have found this workshop to be helpful in your preparation for the upcoming 2023 ILSA UniSZA International Law Moot Court Competition. We are honored to announce that we are honored to announce that the registration date for the competition has been extended until the 30th April of 2023. Is that correct, Umasri? Okay, yeah. Okay, that is all. We hope to see all of you in our next workshop. There will be the third one, which is about the oral submission. Okay, that is all, everyone. Have a great day. Thank you. Bye-bye.
Thank you.
Okay. We can stop recording now, right? Yusuf, stop recording.